Cancellation of removal is a remedy available to certain people who have been found by an immigration judge to be subject to deportation. Congress created it in 1996, amending prior waiver provisions. It allows immigration judges to exercise discretion to not deport certain people who could be deported. One thing to know about cancellation of removal is that a person can get it only once in his or her lifetime. There are three kinds of cancellation of removal. LPR, or legal permanent resident cancellation, is for permanent residents who are deportable usually because of a criminal conviction. There are three main requirements. First, at least 5 years as a legal permanent resident. Second, you have to have at least 7 years of continuous residence in the United States after having been lawfully admitted in any status. And third, no aggravated felony convictions. In order to win cancellation of removal, the respondent typically has to show rehabilitation or at least remorse. There are two types of cancellation for people who are not legal permanent residents, either one of which results in a grant of legal permanent residence. To qualify for 10-year cancellation, the person has the main requirements are at least 10 years of continuous residence in the United States, good moral character during that time, an exceptional and extremely unusual hardship to the person's parent, spouse, or child who is a U.S. citizen or permanent resident. Here, too, Congress drastically cut back on who could qualify for the relief. Before 1997, the standard was extreme hardship, and a person could qualify based on hardship to him or herself alone. The new standard of exceptional and extremely unusual hardship usually requires some special circumstance, such as a U.S. citizen child with a major illness who would be forced to accompany the parent back to the home country and would not be able to get adequate care there. There can be benefits to applying for cancellation of removal, including being eligible to apply for work authorization throughout the pendency of the case. However, once the case does get to a resolution, most people will lose because of the amped up hardship standard. The second kind of cancellation of removal for people who are not permanent residents is for battered spouses or children of U.S. citizen or permanent resident abusers. Congress created it in 2000 along with separate provisions that allow this type of victim to petition for him to immigrate him or herself rather than depend on an abuser to apply for him or her. It's called Special Rule, or VAWA, Violence Against Women Act cancellation, and the basic requirements are battery or extreme cruelty by the requisite type of abuser, at least 3 years of continuous presence in the United States, all with good moral character, and extreme hardship to the individual or his or her parent or child. For both kinds of non-LPR cancellation, there's a $4,000 per year cap. These numbers are used up quickly, so the cases are backing up in the immigration courts, and some judges are simply shelving the cases indefinitely, putting people into kind of immigration limbo. Overall, aside from VAWA cancellation, the cancellation of removal provisions have dramatically cut back on the discretion of immigration judges. This is a problem because deporting people who have been residents of the United States for a long period of time can have drastic effects, particularly where they're a U.S. citizen or permanent resident children and spouses. If Congress is going to make the immigration laws more fair and effective, it's going to have to do something about the cancellation of removal provisions.